Good afternoon, everybody. I hear this is the last presentation, so I'd like to say they saved the best for last, but given everybody that went before us, I don't think that's appropriate. But anyway, hope this helps. And I think this presentation is apropos because this is actually regulatory reminders to the finish line. So this is actually kind of wrapping up the day, which makes sense because this is those later stages where everything's going to be kind of wrapped up and moving towards approval. So we're hoping to get that action. So I think it's a good way to cap the conference and close it out. So myself is Captain Sansone. I represent the Division of Project Management. With me today is going to be Rinku Patel. She represents the Patent and Exclusivity team. And we thought it would be befitting to do this presentation together because the Division of Project Management and the Patent and Exclusivity team actually work hand in hand when it comes down to these final stages to approve an application. So we thought both groups together would be adequate to present today. So when we talk about regulatory reminders to the finish line, what we're actually talking about is finishing up those last stages to approval. So your application has made it through those rigorous scientific reviews. You know, you're moving into the final stages. Your deficiencies have been deemed adequate, and you're looking at getting that application right next to the finish line, getting that approval letter that you want. So that's kind of where we're kind of at right now and what we want to monitor in between that. And you'll see us kind of reiterate the word vigilance and monitoring throughout this presentation, because this is really where you want to, you know, don't lose gas, right? You want to step on the pedal here and make sure you're watching things that will come over today to make sure we get that application to approval and it gets to you as soon as we can. And I guess it's important to also note that, you know, we have a shared interest, right? The FDA and industry to get that application to approval. We want to make sure that we facilitate, you know, generic entry just as much as you want to get that application approved for the same reason. So we kind of have a shared interest in this category. So we definitely need to work together. It takes a village, and that's what we need to do. So what are some of our learning objectives for today? We're going to discuss how and when to respond to changes to patent information. And we need to be very cognizant of the fact that these changes to patent information occur throughout the life cycle of an application, right? It's not just when you submit the application that these changes stop. Changes occur throughout the life cycle application because you have a lot of confounding variables that are happening outside of your control as well. And again, you need to monitor those changes. We're also going to review the best practices for ANDA applicants. So what to do when these changes arise, what to do when these changes occur, how to address them, what's the best way to get it done, things like that Commander Rinku will go into and give you a little bit more detail, and that'll get you through the next phases of getting this application to approval. And then lastly, we're going to bring it all together. We'll go over some other things that you need to be vigilant and cognizant of to monitor for your application, and we'll wrap it up all together, hopefully so that you can see the bigger picture and how this application is going to get to its final stage. So we didn't want to step off the gas here a little bit, and we wanted to also talk about what is industry doing well. Well, industry is doing well at the beginning of the submission, and the pretext of this slide is all at the submission of your application. We find that these 4 bullets kind of being addressed during the initial stages of your application when you're submitted at filing. You guys are the industry certifying to all patent listed, doing a great job there. Please keep that, you know, keep that going. You're providing timely notice. That's good. You know, you're notifying the NDAs, et cetera, of your patents, patent certifications. You're submitting the documentation of notice for original P4 certifications that we have to have as a regulatory requirement. So you're submitting those documentations of notice on time. And you're also notifying the FDA of the first civil action complaint, meaning, you know, hey, if you guys got sued or industry was sued when you submitted these notices, you're telling us of that fact, which is good. But this is all on the onset of the application. You know, this is at the time of filing, which you're doing a real good job of. But we want to make sure you guys understand that this not only stops here, this also matriculates through the application process, meaning you're going to have to, you know, monitor for the patent changes to the Orange Book, et cetera, and things like that, and make sure you're meeting all the necessary regulatory requirements that ensue. So it doesn't just stop when you submit the application, it goes all the way up to the final approval. And again, we're at the final approval stages. We want to help you break through that barrier, make sure you're not missing anything, not have us kind of try to chase you down to make sure you submit necessary regulatory documents that would hinder approval. That's where you're going to get stymied. So I think Commander Rinku is going to go over some of these specific details of where we've seen applicants might need a little help and a little bit more information.
Thanks, Vince. As he said, in the next 3 slides, I'll be sharing common deficiencies and sort of observations that we have, as well as identifying areas of improvement. So going to the first bullet here, addressing timely submitted later listed use codes. So you might be asking yourself, when can that actually happen, right? When can an NDA holder submit a new use code, or what could trigger an NDA holder to submit a new use code that for a patent that's already been listed in the Orange Book? There are a handful of instances where a newly listed use code can be submitted and to be considered timely listed. A common situation is when an NDA holder has obtained supplemental approval seeking a new indication, and they submit a updated patent information within 30 days of approval of the corresponding labeling change. So essentially what you would have to do if the patent is submitted or the use code submitted to and is considered to be timely listed, you've got 3 options. You're either going to submit a Section 8 statement indicating that you're planning to carve out that indication and sort of initiate the carve out process, or you're going to be retaining the protected information, and in which case you've got 2 options. You're either going to state that you're going to wait until the patent expires and submit a paragraph 3 certification, or you're going to challenge the patent and submit a paragraph 4 certification. Either way, you must be consistent across all patents that are associated with that use code or similarly worded use codes. What we often see is applicants trying to take the original paragraph 4 certification and state that they have already addressed the patent and therefore the use code with their previous P4 and notice. However, we require you to submit new P4 certification. Simply put, a previous P4 certification and notice associated with that previous certification cannot cover a new use code that was submitted after the original notice was sent. Therefore, it's not acceptable to address the use code without submitting a new certification. And essentially, by the virtue of a P4 certification, you have to send a new round of notice. Some of the common challenges that we run into is sort of showing adequate documentation of notice. And there are times where you guys do really well and you guys submit, you've addressed the use code with a P4 certification and you've noted and you've sent the documentation, but you just haven't told us about it. So when you've done the first half of it, be sure to submit the other half of it so we know that you've done that. And the other sort of instances where we often see is that notice itself is not aligned or incomplete with the requirements under 31495, the notice requirements. So be sure to ask yourself, have I checked to see if the right applicants got the notice? Was the notice sent to the right address? And more importantly, was the notice actually delivered? So transitioning on to exclusivities, when exclusivity is recognized for the relied upon listed drugs such as 3-year exclusivity or orphan drug exclusivity, there are 2 potential pathways. You either are going to retain the protected information in your label, or you're going to omit the protected information and seek to carve out. And you're essentially saying if you're going to be carving out that information, you're seeking approval of the application prior to the expiration of that exclusivity. Either way, just make sure you're clearly stating the intent of how you're going to be addressing the exclusivity. And to the extent that you have a licensing agreement, you've procured something to say that you are able to go to full approval with retaining the protected information prior to the expiration of that exclusivity, you must obtain a selective waiver. And in that waiver, what we're looking for is it on NDA letterhead? Does it indicate the effective date? And to the extent you can, ideally, we would want to know what exclusivities has the NDA holder, or what's the agreement for? What exclusivities has the NDA holder essentially wait for you? So we all know folks are eager to get their applications approved, and so are we. We want to help you guys get to the finish line and get that application out the door. However, it's imperative for you to submit litigation status on patents that give rise to a 30-month stay. Otherwise, we'll assume that the earliest lawful approval date is the expiration of the 30-month stay. And the regulations do require that an applicant under 314-107 does require the applicants to submit within 14 days of the decision that's been entered by the court, submit that information to the agency. And so for all the information, for all the hard work that you've done and that you made sure that you've got the litigation terminated, just tell us about that, and tell us about that so we can help you navigate what the earliest lawful approval date is. One area that we sort of run into as well is whether or not the order itself was signed by the judge. What we can't do is assume that the proposed stipulation in order is what you guys have agreed to, because it's possible that there's another agreement that happened after you have submitted the one you've sent to the FDA. So what we want to know is it signed by the judge? Is this the order that terminates the 30-month stay? And additionally, the regs do require that these order must be signed. So again, providing us with the litigation status helps us determine what the earliest lawfully approvable date is for your application. Now shifting gears to sort of post-approval requirements. Commercial marketing requirements are required for both sort of the traditional patent challenge 180-day exclusivity for those who were considered to be first applicants who have challenged a patent, or for first approved applicants who satisfy the definition of competitive generic therapy in the exclusivity sort of provisions. So to highlight some key points in relation to the traditional 180-day exclusivity, commercial marketing notification must be submitted in order for us to know that you've triggered your 180-day exclusivity. Not only does it benefit you, it will also make an impact on any other approved applicants to indicate whether or not they have to sort of initiate, or they essentially know that they've triggered, that 180-day has been triggered. 180 triggered, 180-day exclusivity, any triggering of that also impacts any unapproved products as well. By the definition and sort of what the statute provides is that commercial marketing, not only of your drug, but of a listed drug, so that means authorized generic, you must send that information to us as well. And then to the extent that you are a first applicant that was approved, but you did not secure final approval or tentative approval within the 30-month time, and what we did is we punted on your 180-day exclusivity, it's possible that you're still eligible for that 180-day exclusivity, but you have to, looking at the approval letter, you have to indicate that you've actually commenced marketing. So to avoid losing the benefit of part of the 180-day exclusivity, you must submit this information within 30 days of when you've commenced marketing. If you do not submit this information within 30 days, the date of approval of your application will then govern the date that the 180-day has been triggered. I'm going to say that again. To avoid losing the benefit of the 180-day exclusivity, you must submit the required documentation within 30 days of when you've commenced marketing of your application. If you do not submit this, the date of approval will then govern the date the 180-day has been triggered. And sort of shifting gears to CGT exclusivity, the blocking effect for folks who are sort of in this arena and have had an approval letter, you will indicate, which indicates sort of in length what the requirements are. We will not be blocking any other approvals from happening until you've triggered your 180-day exclusivity. So it's very imperative for you guys to submit that information to us. The letters say that they have to be submitted to your ANDA file, as well as indicating and letting the patent and exclusivity team be aware of that in order for us to prevent or halt any other approvals, or any other subsequent approvals. And the forfeiture space for CGT exclusivity is very simple. If you don't commence marketing in 75 days, you've forfeited your exclusivity. We try to provide as much transparency as possible. The Paragraph P4 website and the CGT websites both indicate the eligibility of forfeitures, or the eligibility of 180-day exclusivity, and whether or not an applicant has forfeited, as well as indicating when they've commenced marketing. So, Vince, I'll turn it back to you.
Okay, so why am I back up here? Well, you've walked through all the patents, you've gotten everything straightened out, you're now in those final stages. Well, you want that letter from the Division of Project Management saying, hey, my application is approved, right? That's the end goal. That's the goal of all of us, to get this application. Well, we still want to reiterate, just because you've, listen to Rinku, you got our presentation down. That's not where it stops. Monitoring is paramount, and it's paramount throughout the life cycle of the application. There's other things you want to make sure you've been vigilant of. Some of those things, just to make reference here, USP updates. Are you conforming? Make sure your facilities are in line. Did any of those facilities become withhold, or there's a problem with the facilities in the late cycle and the end of that could derail it? You want to make sure that you monitor the Orange Book, and you want to make sure you monitor drugs at FDA for RLD updates. You need to monitor these things. If you monitor these things and act accordingly and in an expeditious manner, you will get to that final finish line for approval. So again, monitor. If we ask, anything of a Reg Affairs department externally, it's be vigilant, make sure you stay on top of things, stuff that are outside of our control. NDAs are submitting supplements to their respective applications all the time. Are you modeling the labeling accordingly, et cetera? All those things need to be monitored by the external stakeholders, industry. So we want to make sure your Reg Affairs department are doing their due diligence. That way you can help us, and we get to that same overarching goal to get that application out the door. So that's kind of where we're wrapping up. We'll go over some challenge questions now. So the first challenge question is, within how many days are you required to submit notification of court actions or consent to approval? 60 days, and we'll go through the end. 30 days, 14 days, or 10 days. This is where I would usually go around the room using the Socratic method, but I'll spare you guys since the room is so empty. Answers 14 days. So that's the time you need to make sure all your court actions and consent to approval are sent. Challenge question 2. Which of the following statements is not true? I can be eligible for final approval before the 30-month stay expires without having to submit a court action. A court order does not need to be signed by the judge. There is no set requirement to submit a documentation of notice. Lastly, my original P4 certification will cover a newly listed use code. I hope nobody guessed B, because I think that was our easy giveaway. But the correct answer is all of the above, right? These are not true. So we want to make sure that you guys do all these things in a timely fashion. Rinku went over a little bit in this presentation. Submit those notices, submit the documentation, submit the necessary regulatory requirements, and you'll get your application to approval.